I want to introduce now our speaker, Douglas Kysar. The program tells you some of Doug's impressive credentials. A top graduate of Harvard Law School, professor at Cornell, now a professor and deputy dean at Yale, a prolific and widely recognized scholar in environmental law and torts. I've had the pleasure and honor of being Doug's colleague for his first 5 years of law teaching, and I want to add a few things about him that the resume doesn't provide. First and foremost, as impressive as his credentials are, he's even more impressive in fact. He's a truly gifted and conscientious teacher. At the end of his first year on the Cornell faculty, the graduating class elected him to be the faculty speaker at graduation. A new teacher to get that kind of acclaim that quickly and to get it teaching professional responsibility was an incredible feat. At some point during his first year, Doug asked me if I could read a piece that he was writing on the recent census and offer some comments. By the time I got to page 5, it was obvious to me that Cornell had hit the jackpot when it hired him. There are some characteristics as a scholar that you either have or you don't. Creativity and an ability to think outside the box are two of them, and Doug obviously has both in abundance. He also has the rare ability to explain difficult and concept ideas in a way that's illuminating for others. Finally, let me mention one other aspect of Doug that his resume doesn't tell you. That is, he's not only a great teacher and scholar, but also someone who's genuinely down-to-earth, warm, and fun. He and I attended more than a few concerts together during our years together in Ithaca, including some by a singer-songwriter from Minnesota whose name escapes me. And those are definitely some of my fondest memories of those years. Without further ado, let me present Douglas Kysar, the Deputy Dean and Joseph Field Professor of Law at Yale Law School.
Well, let me begin by saying how honored I am to have the opportunity to speak to you at this event. I understand that Mercer has a strong tradition of celebrating Law Day. I think that's evidenced by the awards that are going to be bestowed upon Judge Laney, Mr. Davis, and Mr. Adams later today in order to recognize their remarkable careers and accomplishments. I'm honored to be in their company, and I'm proud to be a part of this tradition. It's also a great privilege for me to be here at the invitation of Dean Gary Simpson. As Gary mentioned, we were on the faculty together at Cornell. He was my friend and my mentor when I first started teaching 12 years ago. And he provided for me then, as he does now, a shining model of how it is that one can live as a brilliant scholar, an inspiring teacher, a generous colleague, a loyal friend, and a loving spouse and parent. He's simply one of the finest individuals I know in all of law teaching and in all of life. So thank you, Gary, for this reunion and for everything you do. Now, as you may know, every year the American Bar Association provides us with a theme for Law Day. And the 2012 National Law Day theme is No Courts, No Justice, No Freedom. It's an important message and a timely one, for I fear that the essential connection between our courts, our justice, and our freedom is less well appreciated today than it ought to be. The founders of our country and the framers of our constitutional system of government clearly understood this connection. And the founders and the framers of your state constitution did as well. Paragraph 12 of the Georgia State Constitution is entitled Right to the Courts, and it provides that no person shall be deprived of the right to prosecute or defend that person's own cause in any of the courts of this state. Earlier versions of this right of access to the courts in your Constitution provided the right of the people to appeal to the courts shall never be impaired. And most every state constitution in America contains a similar provision. I want to suggest to you today that there is a deep wisdom archived in these provisions, and that we would do well to revisit that wisdom as we struggle with the challenge of governing our country and our world in the 21st century. My argument will start by claiming that our distinctive constitutional tradition has long relied on open access to courts by the citizenry as a way of alleviating the pressure that comes from having a system of limited government. Because we have an evolving common law of rights and responsibilities, and because our courts are open to citizens as a residual locus for the airing of grievances when other official avenues have failed, we are able, as a result, to have less government, fewer rules, and a smaller bureaucracy than we otherwise would require. I will then argue that this residual forum for the airing of grievances can serve a vital catalytic role for government in the coming decades. Many 21st century threats to our well-being demand greater governmental responsiveness and openness to institutional experimentation. We face new kinds of harms that are practically unlimited in the number of sources that threaten the harm or in the severity of the impacts that the harm imposes. I write and study and teach about climate change, so climate change is, in my view, the paradigmatic example of this new kind of unlimited harm. But it can also be glimpsed in other problems like global financial regulation, anti-terrorism, pandemic prevention, and a host of other public policy challenges. These kinds of challenges are not going to be solved by courts. I want to be very clear and upfront about that. But I do not believe that means courts have no role to play in confronting the challenges. It is a vital and underappreciated fact that our courts are constitutionally required to remain open to the airing of complaints. And our courts are required to give us a reasoned answer to the claims that are brought before them. Our courts can't just say, "Get out of here." They have to tell us why. In other words, our courts must afford us the dignity and the respect that comes from being given reasoned answers. And the rest of our government is under no such obligation. What I want to suggest is that this forum, this unique opportunity for reasoned public confrontation of harms and wrongs, can play a critical role in prompting ultimate engagement with public policy problems that might otherwise appear too complex, too sprawling, or just plain too scary to address. Put more grandly and more provocatively, I'm going to suggest that our anxiety about government today should focus not only on whether our system of checks and balances can safely constrain collective action, but also on whether the system can ensure that collective action does happen when it's necessary. So let me begin with tort law, the law of civil wrongs. Seen properly, tort law is a pillar of private law. Parties are empowered to seek redress from their wrongdoers using the authority of the state through court proceedings. Tort law evolved and continues to evolve from the moral primitives of trespass and battery. Those two basic wrongs work to provide us with security of body and property. And when a tort has been committed upon us, we can invoke the power of the courts to serve as a neutral arbiter and as an upholder of the principles of right and responsibility that tort law defines. Tort law is not to be understood as a regulatory device, although many legal scholars and some judges have come to see it that way. Unlike laws and regulations that are enforced by agencies, tort law adjudicates the claims of specific victims, that they have been injured by the conduct of specific wrongdoers. This kind of mechanism serves many vital purposes in our democracy. It helps to constitute an ongoing, principled determination of the content of the duties that we owe to one another. It helps to repair the harmful effects of wrongful conduct according to tenets of corrective justice. It helps to reinforce ideals of social equality and individual responsibility. And it helps to afford a vital procedural mechanism whereby those who are suffering harm and those who have contributed to harm can face one another in a process that is dignifying to both rather than being denigrating to either. A bedrock feature of the Anglo-American legal tradition has been this entitlement of injured parties to seek to persuade an impartial court that they hold a right of action against their wrongdoer. Chief Justice Marshall, one of our greatest jurists, clearly understood this. In Marbury versus Madison, he wrote, "The very essence of civil liberty consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection." Well, for centuries in the Anglo-American tradition, the essential manner in which government has fulfilled this duty has been through courts and the common law. Allowing parties to press their claims furthers the project of individualism because it respects litigants as agents who can assert rights, make arguments, demand redress, rather than merely as passive beneficiaries of protective regulations that are imposed on them from above. It also furthers the project of limited government by allowing our complex system of laws and regulations to be somewhat smaller than it would otherwise need to be in order to keep us safe and prosperous. Now, I've admittedly just given you a very romantic view of courts and the tort system, one that might sound odd to your ears if you are more accustomed to hearing instead about how activist judges and runaway juries are wreaking havoc on the country. The judiciary and the tort system both are under attack in our country, as evidenced by tort reform legislation and by the increasing politicization of judicial elections, just to give you a couple of examples. In my view, these trends are somewhat worrisome, and not only because they disregard the traditional role and significance of the civil justice system, but also because they may undermine our ability to cope with the future. We have a governmental framework of limited public authority, and we remain committed to that framework for very good reasons. But now our limited government must survive in an era of unlimited harm. Now, what do I mean by unlimited harm? That sounds a little hyperbolic. Well, I think we face unlimited harm in at least two different senses. First, the source of some injuries now are so numerous and dispersed, or so unpredictable and evasive, as to be unpreventable, at least in any traditional fashion. Climate change, again, is an obvious example. We're repeatedly reminded, correctly, that any domestic efforts we make to lower greenhouse gas emissions will matter zilch without a mechanism for also limiting the remainder of the globe's 7 billion emitters. Now, global economic risk is similarly diffuse and wide-reaching. Interlinkages of finance and trade create opportunities for growth, but they also render any individual jurisdiction vulnerable to systemic risks that might arise from far outside of their regulatory authority. The frequency and the density of international travel and migration creates a similar dilemma with respect to infectious diseases, the risk of global pandemics. Finally, threats of terrorism are not pervasive in this sense, but they still might be practically unlimited. There's clandestine weapons markets and global communication channels that allow the recruitment of anyone, anywhere, into the cause of destruction. And that pipeline of recruitment might be monitored, it might be constrained somewhat, but it cannot be entirely shut off. Harm may also be unlimited in a second sense. The potential impact of some harms is both catastrophic and resistant to estimation. For instance, climate change scientists have identified a variety of scenarios in which global warming spins wildly out of control, with harmful effects of an unprecedented, almost biblical magnitude. Yet the mechanisms underlying these scenarios are not sufficiently well understood to assign precise probabilities to their likelihood. As a result, the tails of our probability distributions are very fat and very fuzzy. And somewhat paradoxically, more knowledge often makes them more fat and more fuzzy. The challenge is similar for other catastrophic threats. Before the events of September 11, 2001, or the financial collapse of 2008, or the Deepwater Horizon spill disaster of 2010, before those events, knowledgeable observers warned that those threats were not only imaginable, but they were likely. Yet their warnings were not easily assimilated into our safety protocols or our risk models. How do we guard against a terrorist who's determined to be indeterminable? How do we price the risk of collapse of global financial markets when they're the very mechanism that gives rise to price? How do we prepare for the worst when our history with an activity is limited and deceptively reassuring? I think limited government faces grave challenges in this brave new world. Our founders were famously worried about the concentration and abuse of public power. They sought to minimize the risk of government by distributing public authority horizontally and vertically. And even as the world has changed dramatically, the fears of our founders continue to guide our thinking. As the scholar Richard Pilders notes, constitutional theory and design have been dominated by the specter of legislative and executive institutions voraciously seeking to expand their powers. But in modern political practice, the flight from political responsibility, the problem of political abdication, is at least as serious a threat. In a world in which government has enabled private entities to amass power as breathtaking as it is elusive, and in which minor harms of diffuse, unregulated origin have accumulated into threats of catastrophic magnitudes, in such a world, the basic goal of preventing the aggregation and abuse of power should perhaps be applied more broadly than to the formal apexes of government authority. The critical goals of balancing and limiting power may sometimes require more, not less government activity and responsiveness. Rightfully wary of government oppression in the founding era, we may nevertheless have splintered and hobbled our government too well. Well, one way I think in which government actors can modestly adapt to this brave new world is by performing their official roles with a self-conscious appreciation for the ways in which they can signal to other institutional actors, other members of government, that a given problem demands attention and action. Let's call this function prods and pleas, a corollary to the more traditionally emphasized function of checks and balances. Even when a social need exceeds the scope or the capacity of a government actor, he may still acknowledge the seriousness of that need and the desirability of action by other governmental actors. Just as the existence of divided and overlapping authority creates opportunities for those institutions to check and balance one another, it also opens space for them to prod and plead with one another when the danger is one of government underreach. In that sense, prods and pleads are the second blade of a pair of scissors. Here's some examples of what I mean. Regulatory agencies might proceed with a rulemaking that's admittedly much less desirable than legislative responses, precisely in order to prompt Congress or a state legislature to overcome its inertia and its dysfunction. Or governors might engage in a form of state civil disobedience, pursuing, for instance, policy coordination with foreign governments, despite serious doubts about the constitutionality of that action. Mayors might decide to confer marriage licenses on same-sex couples. Local school boards might prohibit the teaching of evolution. States might adopt restrictive policies toward illegal immigrants. All of these actors knowing that their actions may be swiftly overruled by higher authorities, but they're hoping in the process to prompt sustained democratic engagement with their perceived area of need. All of these actions can be understood as efforts to trigger dormant institutional hydraulics that help a limited government acknowledge and address areas of social harm or discontent. Now let me tell you what I think is an important example of prods and pleas: climate change tort litigation. Right now, out in the Ninth Circuit, plaintiffs are awaiting a ruling on whether their lawsuit, Native Village of Kivalina versus ExxonMobil Corp., can proceed. In this suit, the city of Kivalina, Alaska, and its Eskimo residents are challenging a group of oil, energy, and utility companies. They're asking for monetary compensation for expenses that they need in order to relocate their town. The Army Corps of Engineers has determined that the village of Kivalina must be relocated imminently on account of permafrost erosion and sea ice decline and other manifestations of climate change. Now, the village represents a very sympathetic plaintiff. Its constituents are among the most vulnerable people in the world to the impacts of climate change, and they're also among the least responsible for producing them. Now, notwithstanding all of those strengths, the federal district court dismissed the Kivalina case on narrow preliminary grounds, and the Ninth Circuit Court of Appeals is very likely to uphold the dismissal. In fact, every trial judge so far who's faced a global warming nuisance claim has dismissed the case without addressing the underlying merits of the claim. In my view, these judges need not be so worried. If the claims were allowed to proceed to the merits, the judges would find ample doctrinal weaponry to stop the claims from succeeding. Unlike more familiar forms of pollution, greenhouse gases do not directly and locally impair human health or ecosystems. Instead, they begin as largely harmless gases before globally dispersing throughout the atmosphere, warming the planet's surface, and triggering a laundry list of complex ripple effects throughout all natural systems that eventually manifest in individual harms. And similarly, the class of climate change defendants includes, in the extreme, anyone whose activities result in net greenhouse gas emissions, which is to say, every natural and legal entity on the planet. So problems of remoteness and attenuation don't just describe climate change as a policy challenge, they define it as a policy challenge. And built as it is on a paradigm of harm in which A directly, wrongfully, and exclusively injures B, tort law is ill-equipped to address climate change. Diffuse and disparate in origin, lagged and latticed in effect, greenhouse gas emissions and climate change represent, in a sense, the paradigmatic anti-tort, a collective action problem that is so pervasive and so complicated as to render at once all of us and none of us responsible. But, and I think this but is important, judges should not avoid these cases by using preliminary devices like standing or political question doctrines. Instead, judges should forthrightly address the merits of the plaintiff's claims as they historically have been obliged to do. Just as open trials afford democratic participation by allowing citizens to interpret and not merely observe the judicial process, merits adjudication of torts claims promotes consideration of the underlying visions of right and responsibility and social order that are adopted by a judicial decision. In fact, rather than counseling against common law adjudication, the complexity and the enormity of the climate change problem actually counsels in its favor, simply in order that baseline norms of responsibility, whatever their content, might be more clearly specified. Soon enough, public and private actors all over the world will need to embark on what will become a centuries-long struggle to deal with greenhouse gas emissions and their impacts. As they do so, they need some baseline understanding of what constitutes reasonable behavior when it comes to greenhouse gas emissions. And tort law can, and historically has been obliged to provide that baseline, even if the baseline understanding is simply burn those barrels while you still can. In so ruling, courts would reveal a gap between the common law's basic ideal of protection from harm and the failure of other branches to step in when the complexity of that harm renders it unsuitable for judicial resolution. Tort law is partly a guarantee of official avenues for individuals to seek redress. It also represents a constitutional mechanism whereby limited government is forced to perceive the consequences of its limitations. In that sense, what I'm calling prods and pleas are really as conservative as they might sound radical. They serve not to undermine the basic structure and principles of limited government, but rather to protect them against daunting threats to their existence. The tort system is a vital source of information gathering and intra-governmental feedback. Judges, when they struggle to apply common law principles to the harms of an ever more complex and interconnected world, judges deliver dignified public pronouncements that legislative and administrative inertia have left our basic ideals unprotected. And by doing so, they enter into the conversation about what actions are called for and why. They do so by holding up particular problems to the light of deeply held common law values. By contrast, when courts shrink the common law scope through procedural doctrines or other non-merits maneuvers, any suggestion they might make about whether and how a legislature should act comes wrapped in a self-effacing disclaimer, a statement that the norms of the common law do not apply here, could never apply here, and hence an admission that the court lacks the institutional authority to suggest that the other branches should take any particular action or even to act at all. In my view, this is a terrible lost opportunity. Precisely because of our imperfect divisions of authority, judges and other government actors will always be pushed into areas of overlapping authority, asked to resolve tasks at the very boundaries of their institutional scope and competence. In responding to these challenges, they often will conclude that they cannot address an area of social need given their institutional constraints. But they can still deliver that conclusion in a manner that's designed to instigate an official response elsewhere in the system. Whether or not judges accept invitations to recognize new rights or expand common law protections to cover new harms, the important point is that they should expect the invitations to keep coming, as long as the basic framework of American government remains intact. In that sense, climate change tort suits should feel comfortably familiar to judges despite their enormous factual and moral complexity. And nor should judges be disturbed that the harms from climate change seem at once to constitute a garden variety pollution nuisance and at the same time a conceptual threat of the highest order. Protection from harm, freedom of action, they form an antinomy at the very heart of tort law, one that inevitably implies a gap between our principles of tort and their implementation. This shortfall is clearest in the case of non-negligent harm to an innocent victim, where the plaintiff's interest in being free from harm clearly clashes with the defendant's interest in pursuing freely reasonable activity. Every dispute, though, between private litigants in tort can be understood to implicate competing principles of our basic social contract, ones that can never be enforced to their fullest conceptual limits. And despite its discomforting quality, that gap is in fact actually a very productive one, because it's in that gap, that space, where litigants and judges pursue the reconciliation of competing principles and the adaptation of our traditional values to changing circumstances. It's also within that gap that judges can meaningfully prod and plead with other government actors, so long as they maintain the courage to do so. Climate change is the ultimate tragedy of the commons. Not only fossil fuel companies, industrial manufacturers, but all human beings, all human enterprises contribute, however marginally, to the phenomenon of climate change. And isolating where responsibility attaches in that complex system is therefore an intellectual and a moral challenge of the first order. But when even the most dystopian climate change scenario, such as the complete erasure of homeland for a distinct and a long-lived human civilization, when even that scenario fails to register as the responsibility of any actor anywhere, then our principles of causal and moral attribution might need to be rethought. And as with earlier periods of evolution in response to suffering that's uncompensated and undeterred and unrationalized, courts simply cannot avoid playing an active role in that evolution. No courts, no justice, no freedom. Thank you.